If you are an irresponsible individual, you should not be allowed to carry a concealed firearm. But while we wait for them to do more to keep Californians and Americans safe, we're going to act.
See hope and optimism. People thought that the federal government would never be able to get a gun law bill passed again. They got one done in the last year. For a case to be brought to go in front of one of those judges and to have an outcome similar to what we've seen in the past. Far-reaching gun law in the history of the world, it is not. But they actually did it.
California's arms banned at fairgrounds. Well, folks, California is back at it again with its controversial arm laws, and this time it's all about fairgrounds. On Tuesday, the U.S. Ninth Circuit Court of Appeals declared that the state's laws barring the sale of arms and ammunition at fairgrounds and other state property are totally constitutional. That's right. No more buying arms while munching on cotton candy at the fair. The man behind the ruling, Judge Richard R. Clifton, was pretty clear in his decision. Writing for a unanimous 3-judge panel, he dismissed the claims from a group of arms sellers and arm advocacy groups that these laws violated their First Amendment right to free speech and their Second Amendment right to bear arms. Clifton didn't mince words, saying the laws only restrict non-expressive conduct, basically the act of selling arms, and don't really mess with anyone's ability to own them. But not everyone's happy about it. Tiffany D. Chevront, the lawyer for the arms sellers and advocacy groups like B&L Productions, Inc., the folks behind Crossroads of the West arm shows, and the California Rifle and Pistol Association, is fuming. She called the decision extremely disappointing and promised an appeal. In her statement to the Times, she claimed the judges clearly did not understand the connection between First Amendment and Second Amendment rights and accused the state of discriminating against certain groups on state property. On the other side of the fence, Governor Gavin Newsom couldn't be happier. He called the ruling common sense and a big win for armed safety. Newsom, always ready with a zinger, said if other states followed California's lead, thousands of lives would be saved. He made it clear that California isn't backing down from what he called the rights radical lawsuits. Way to throw shade, Governor. California Attorney General Rob Bonta also jumped on the victory train, praising his team for their hard work. Bonta's statement was crystal clear. Arms should not be sold on property owned by the state. It is that simple. He emphasized that sales of illegal arms and ammunition, along with sales to prohibited persons, have happened on state property, and these laws are a step towards preventing that in the future. Kudos to Bonta for not pulling any punches.
Their outcomes are dangerous, and that is a problem. Their legal analysis is poor. Their conclusions are misguided. See hope and optimism. People thought that the federal government would never be able to get a gun law bill passed again. They got one done in the last year. For a case to be brought to go in front of one of those judges and to have an outcome similar to what we've seen in the past.
Gun violence is truly America's disease. We choose to change the trajectory of where we've been and to end the gun violence epidemic.
Now let's dish a bit about the judges. Clifton, an appointee of President George W. Bush, teamed up with circuit judges Holly A. Thomas and Rupali H. Desai, both of whom were appointed by President Biden. Talk about a bipartisan effort. This decision resolves 2 cases where lower courts couldn't agree and lifts an injunction that had previously blocked the state from enforcing these laws. This ruling comes amidst a broader debate over where states can ban arms, especially after the U.S. Supreme Court's 2022 decision that said laws infringing on the Second Amendment are only legitimate if they're deeply rooted in American history and tradition. But the Ninth Circuit's decision cleverly sidestepped this historical debate, focusing instead on the specifics of the Second Amendment. Clifton's take? The Second Amendment protects the right to keep and bear arms, but it says zilch about the commerce of arms on state property. According to Clifton, banning arms sales at state fairgrounds doesn't mean people can still buy arms elsewhere. Merely eliminating one environment where individuals may purchase arms does not constitute a meaningful constraint on Second Amendment rights, Clifton wrote. Translation: just because you can't buy an arm at the fair doesn't mean you can't buy an arm. And let's not forget, these laws don't stop arms sellers from talking to buyers at arms shows on state property. Buyers can simply step off the fairgrounds and order whatever they want. No biggie, right?
Far-reaching gun law in the history of the world, it is not. but they actually did it. Every one of these mass shootings, every one of these tragedies deserves action. And sometimes elected officials will act and sometimes they won't. We're proactive. We're preventing. We know what's possible. We know it'll happen again if we don't do something.
Nearly 140,000 Americans who have died from gun violence would still be with us today. It is a direct result of our nation-leading common sense, data-driven gun laws and prevention policies that are intentional.
Of course, this isn't the end of the story. Other challenges to California's arm laws are still winding their way through the courts. These include bans on assault weapons and large-capacity mags, all under scrutiny after the Supreme Court's 2022 decision.
In the wake of the Bruin decision, let me be absolutely clear, this is Bruin compliant. If you are an irresponsible individual, you should not be allowed to carry a concealed firearm. Court case that we can identify sensitive places where concealed carry weapons should not be carried. The evaluations before we provide a concealed carry weapon permit to an individual. And this bill, this approach, it's about the facts.
Reinterpreting the meaning of arm. Arm control is a complex issue that relies on marketing and catchphrases to gain public support. Arm prohibitionists have successfully used phrases like attack weapon, arm crime, arm show loophole, Charleston loophole, buyback, large capacity mags, smart arm, and universal background checks to define the debate. A recent addition, ghost arm, refers to an unserialized arm made by someone other than a federal arm licensee that is considered untraceable. The U.S. Supreme Court has agreed to hear an appeal from the Biden Justice Department that asks the High Court to lift a stay on an ATF rule supposedly meant to crack down on ghost arms. The rulemaking that is currently being debated is called Definition of Frame or Receiver and Identification of Arms, and its objective is to broaden the definition of what is considered a regulated arm according to federal law provisions.
California has some of the strongest gun safety laws in the nation. We have one of the lowest firearm mortality rates in the nation because we have some of the strongest gun laws in the nation. Decades ago, we had one of the highest firearm mortality rates. And if you give everyone a CCW without discretion, there will be more people who are not law-abiding and more dangerous who will get a CCW who can commit a crime. The data does show that those with CCWs in the past across different states have committed crimes.
The purpose of this proposal is to reverse the current classification of what constitutes a regulated frame or receiver in order to ensure that some unfinished blanks or castings are regarded by the law as if they were weapons that are capable of being fired. This means that a piece of metal or plastic that would still need to be machined, filed, drilled, or otherwise altered in order to be usable as a frame or receiver from which an arm could be built would be able to achieve the legal status of an arm simply by being, in the opinion of the ATF, readily convertible for the purpose of being used as an arm. The problem the rule supposedly seeks to address is that technology has made it easier for individuals to build their own arms, and building arms from unregulated parts gives those who are prohibited under the law another way to obtain them without creating the paper trail associated with licensing, manufacturing, and sales. Lack of serialization also makes it more difficult to determine where an arm originally came from if it is recovered at a crime scene. The problem of tracing arms is a complicated and multifaceted thing to deal with. Identifying the initial retail purchaser of an arm is a process that can be laborious and time-consuming. This technique requires the use of tracing data to determine who the original purchaser was. In order to create broad generalizations about crime arms for the purposes of propaganda or legal activities, organizations that advocate for arm restriction frequently use this data. It is important to note, however, that the ATF notes that trace data was not meant to serve as a valid basis for these generalizations.
Internationally unique tragedy and epidemic when it comes to gun violence. Only here do gun violence tragedies happen as frequently as they do. With this legislation I'm proud to sponsor, we will strengthen the concealed carry weapon laws in the state of California.
Safety in our communities needs to be different. It needs to be tailored strategies to create peace and safety that our communities deserve.
And the federal government to do their part, to act. And let me be clear, they must act. But while we wait for them to do more, to keep Californians and Americans safe, we're going to act.
The authorities that are granted to the ATF by legislation that has been properly approved are the ones that limit the breadth of the ATF's authority. This is especially pertinent in the future case that will be heard by the Supreme Court, which is Garland versus Vanderstock. The case was issued by the United States Court of Appeals for the Fifth Circuit in November of last year. The court came to the conclusion that the agency regulation in question violates the explicit wording of the statute and goes beyond the boundaries that were established by the legislature on the agency's jurisdiction in the name of public policy. The court also made the observation that the meanings of statutes do not change with the passage of time. The agency rule currently purports to enlarge the definitions of the terms frame and receiver as they were understood in 1968. However, the meanings of statutes do not change with the passage of time. The case will be known as Garland versus Vanderstock before the Supreme Court, which will decide how much authority the ATF has to define statutory terms when their new meanings could turn behavior that has been considered permissible for a long time into a criminal offense. This case follows the still pending Garland versus Cargill case, in which the Supreme Court will rule whether or not the ATF has the authority to modify its long-standing view that bump stocks are not considered mash guns under federal law that has been in effect for a long time. Joe Biden, the most anti-armed president in American history, has turned to Merrick Garland's Justice Department and Stephen Dettelbach's ATF to reinterpret long-settled meanings of law to crack down on Second Amendment activity. All eyes in the armed debate will now be on the U.S. Supreme Court as they determine how long a leash the executive branch has to make up the law as it goes along.
In the face of our gun violence crisis, we have a choice. We're going further, we're leaning in, we're going to save more lives. Do we do what many states across this country have done? Do we act? Do we push? Do we do? In California, we're built different. We are different. Not accept the unacceptable, and we will do everything in our power that's constitutionally compliant.
That's all for this video, folks. We'll see you next time.